Good morning, everyone, and a very warm welcome to our final webinar for 2023. My name is Crystal Wright, and I am a principal at the Worrells Wollongong office. It is my pleasure today to be your co-host together with Chris Cook from our Brisbane office. Before we begin today, I would like to acknowledge the traditional owners of the land I join you from today, Dharawal country, and pay my respects to elders past, present, and emerging. I would also like to extend this acknowledgement to the diverse Indigenous cultures and communities represented among our virtual attendees, acknowledging their custodianship of the lands from which they join us. Today, Chris is going to look back at the year that was. He'll be delving into the hidden stories behind the headlines and uncovering the secrets of some of the most interesting insolvency cases we've handled. And of course, we'll explore the rise of the SBRs, the small business restructures, and some of our most successful restructures of 2023. If you have any questions throughout the presentation, please submit them through the Q&A function, and we will try to address them at the end of the presentation. If we are unable to get to them in the time allocated today, one of our team will reach out to you via phone or email in the next few days. Finally, we will be emailing a copy of the presentation together with your CPD certificates to all those attending today to assist you in meeting your continuing professional development requirements. Please feel free to distribute this presentation to your colleagues who are unable to join us today. Now, without further ado, please join me in welcoming Chris Cook. Thanks, Chris.
Thanks so much, Crystal, and welcome everyone to our final presentation for the year, 2023. I know I'm much looking forward to the Christmas break, and I'm sure many of you are as well. So thank you for taking some time out of your day to join us today. This is one of our fun topics for the year. This is the one we enjoy doing. We like it because we get to give you some of the entertaining things that have happened to us throughout the year, but it also showcases some of the different matters that we deal with and where our process and insolvency process can work for clients, to give you and your clients some understanding of sticky situations they might find themselves in. So look, we do hope you enjoy it. If you've got any questions afterwards, as Crystal's already explained, please put them in the chat or reach out to your local principals. So I'll just start off just a usual disclaimer saying, look, this is all fairly general information, hopefully a little entertaining. But certainly if you want to raise anything a bit more specific, please approach any of our wonderful principals all over the country. So I'm going to be, before we get into the case studies, I just want to sort of give you an understanding of how it works when we get appointed. So we generally are appointed by two methods. One is where the director or the person themselves approach us. They need some guidance, they need some help, and we get in. We work with them a little bit beforehand. We work out a strategy, whatever that might be, whether it's an SBR or a VA or a bankruptcy or a controlling trustee or otherwise. We work out that strategy, and then we become engaged and work through that strategy. So we call that sort of debtor-driven work. We also can find ourselves doing creditor-driven work, and that's where the appointment has come through the courts. So generally in those situations, we don't know anything. We're coming in very last minute, and we sort of get a piece of paper to tell us you've been appointed, and then we have to work it out from there. So we'll run through a couple of these examples today. There'll be a bit of both, but what that often means is we can find ourselves sort of dumped into, well, I shouldn't say dumped into, find ourselves put into many different roles. We come in without necessarily full knowledge of all the businesses we find ourselves in. We've got to pick up and work with the director if we can, or the other stakeholders as quickly as we can. And we find ourselves in situations like some of these on the screen at the moment, where all of a sudden we become a landlord to a large building complex, or we find ourselves in the farmer role. We've done many crop farms and livestock farms over the years and find ourselves adapting to that. Now we've pharmacies and things like that, where we've got to get quickly up to speed with the pharmaceutical requirements and the regulations surrounding all of that. So this here is a very short list of some of the things we find ourselves in the middle of. And certainly some of the examples today will show how we sort of have to sort of get dealing with things on the run. So we're going to run through 4 different case studies today, stories, and they're the ones on the screen. There are a number of different types. We've got statutory trustee appointments, we've got voluntary administrations, we've got liquidations and bankruptcy that we're going to talk about. So a bit of a spread. And the idea is to hopefully give everyone watching today a bit of guidance into how each of those types of administrations can work, even if they are a little challenging, like some of these might be. So the first one I want to start off with is a straightforward, what should have been a fairly straightforward, a voluntary administration and liquidation. It was a scenario where we had a company that was operating a photocopy. It had three arms to its business, and this was in central Queensland. It had three arms of photocopiers where it would do sales of photocopiers, servicing of them, parts, that sort of thing, have a service agreement with them. It also had an IT arm where it would provide IT assistance to its customers, and then a telecommunications arm as well. And the background of this is we worked with the director. This is one of those debtor-driven processes that I explained a moment ago. And the idea is we work with the director. We determined a plan, and the plan in this instance was to get us involved and to keep the company trading. We could have done a liquidation, for example, where we just would have put the company straight into liquidation. But the idea was do a voluntary administration with the view of trying to keep the value in the business and sell the business. That was the game plan. That's what we worked out very carefully with the director to do exactly that. So we were appointed as voluntary administrators on 28 October 2022. We had three premises for these different three arms around the state. There were some 16 staff that were appointed, and that did include the director, daughter, and son-in-law. We had photocopiers that were out there dealing with of some 2,000 in the field. So this is sort of the pattern of what we were looking at before we got appointed, and how the process was going to work, and the game plan of keeping this business trading on. The IT division of the company was run by the son-in-law, and that'll come a little relevant shortly when I fill you in on some things that happened there. And then we also, as I explained, the concept and the game plan from day one was to trade this business on through the benefit of trying to sell a business as a going concern. In doing that, we're maximising the return. And the ideal outcome is, with any sale in a voluntary administration, is to keep the employees with a job. They transfer to the purchaser, for example. If you've got landlord premises, then you get to keep a tenant within those landlord premises, do an assignment of lease or new lease arrangement. And in doing all of that, you're reducing your cost exposure. Otherwise, if you're terminating employees, you've got to pay them out. If the landlord, if you go into liquidation and move out, then the landlord would have a large creditor claim. And of course, the big thing is if it's trading on, it's a more valuable business, and hopefully you get a better sale price. That's the game plan, and that's something we do day in, day out. And that's what we planned on this one. The creditors we had in this scenario was a vendor finance arrangement for the business. So they were owed some $880,000. And then we had the ATO and the OSR in for about $550,000. So that's the scene. That's what we'd set up. That's the way it should hopefully go, and we would get the result. Now, the reason I'm talking to you about this one today is because that's not how it played out. So we had some issues that we encountered straight up. The first issue that we had to deal with was the director. So I've explained how we worked with the director to have this appointment take effect, with the idea of getting this result of selling the business. Unfortunately, pretty much from day one, he disappeared. Didn't know where he'd gone, wouldn't talk to us, wouldn't come into the office, wouldn't respond to emails. The employees didn't know how to get onto him. So picture this, we've come in with this business. He's managing the business, three different arms. And we do need the director to assist us in trading this business on. He's got all the intellectual knowledge and all that. So it's very important that the directors work with us in a scenario like this. Unfortunately for us, that didn't happen. So straight off from day one, we're on the back foot. We're trying to keep this business going. And one of the key components of that has walked away. So that was certainly a bit of a challenge from us straight from the outset. Then, as part of our process, we had a dealership arrangement. Well, the company had a dealership arrangement, an exclusive dealership in place before the appointment. Upon our appointment, the dealership then terminated the agreement. And this left us in a predicament because, one, we want the dealership agreement in place because it adds value to the business. If you can sell this business with the dealership agreement, of course, that looks attractive to potential purchasers. And it also allowed us to purchase stock and parts through that to service the 2,000 odd photocopiers out in the field. And of course, we had the ability to sell those particular photocopiers for the sales arm. So immediately when that looked like it was getting terminated, that put us on the back foot again, another issue that we had to contend with. So we did work closely with the dealership, and we did manage to keep an agreement in place where they would continue to provide us with parts and supplies and things of that nature to allow us to service the customers. Because of course, if we couldn't do that, we were going to lose the customers. And again, that affects the value of the business. So that was certainly another one that came out. And it turns out we found out that they were talking to a competitor to us and looking at a dealership arrangement with that particular competitor. And that brought in an entirely new challenge for us. So we had found out through the grapevine that this competitor had actually been contacting staff and telling them that they weren't going to get their entitlements. We weren't going to pay their employee entitlements. And then as such, those staff should go work for this competitor for us. So effectively poaching our staff and telling them facts that were completely untrue. Like that's not how it works. Even if worst case scenario happens and the company goes into liquidation and the staff are terminated, there's a government program called Fair Entitlements Guarantee, or known as FEG, through the Department of Employment, that provides liquidators with the funding to pay out the employee entitlements, your annual leave, your wages, all the usual entitlements except for superannuation. So that was completely untrue. Even if they'd lost their job, they still would have got paid their entitlements. And then unfortunately for us also, he managed to somehow get his hands on the customer client list and actually contacted the customers of the company that we were trading on, telling them that we were closing and then trying to set up service agreements with his entity, the competitor to ours. And in fact, some of them did sign up. And that's when we became aware of it, because they were signed up with him, but still had a service agreement with us. And they were actually double paying the bills at the time. So this was a massive problem for us. And once we found out, unfortunately, we had to get lawyers involved, which comes at a cost, to put him on very clear notice that he was not to continue with this kind of activity. It was misleading. It was deceptive. We reserved our rights to the lost business as a result of him. And then we had to communicate with the customers to try and get them back on deck with us, because of course, the more customers we have, the more value in the business. So we had to work through that process, and that did take our focus, again, another issue to take our focus off this business, keep this business going. And we then had the next issue that popped up was also the staff resigning. So he was trying to poach staff, but we also had a situation. And unfortunately, these scenarios, the staff are always a little nervous. They're worried about their job, of course. So we were working with them to try and demonstrate, look, if we could sell this, the staff could go across to the purchasing entity. That would be an ideal outcome, and they would get to keep their job. And that's certainly what we were working towards. But that doesn't mean they don't get nervous. And unfortunately, there is, for small businesses, there can be a challenge for redundancy. So any redundancy payment requires more than 15 staff to be employed. And you may recall from the outset, on one of the opening slides of this matter, there were 16 staff. So as staff resign, if any staff resign, you get under the 15 employee number, which means the Fair Entitlements Guarantee Program, the one that funds the payment of the employee entitlements if there's not enough money in the company, wouldn't pay the redundancy because they said it was under 15 employees. So by these people resigning was having a detrimental effect on the other ones that were staying, because of all of a sudden they're not going to get their redundancy payout. So we had to get lawyers involved to work through that process to work that out. So again, another issue, trying to keep morale up, trying to keep staff happy, and then they get hit another blow finding out they may not be getting their redundancy. So again, it was just another challenge that was sort of thrown upon us. This one was a little entertaining. I can say that with the benefit of hindsight. It wasn't so entertaining at the time. So I mentioned the three arms of the business, and one of those arms was this IT department. Now, before we get involved in any company and before we trade it on, we make sure that the business is viable for trading on. Otherwise, if it's running at a loss, we're not going to trade it on. It's just not going to happen. And we had done that process. We'd investigated all that, done our due diligence before we commenced, and found that in particular, this IT was profitable. But after we got appointed, it wasn't trading so well at all. And we were sort of trying to work out why the sales were decreasing. We couldn't really pinpoint it. And we had to make some staff cuts, unfortunately. So some of the staff had to be put off because we couldn't trade at a profit on those numbers. And then they contacted us. They whistle blew after the fact and said that the son-in-law of the director had actually 4 days before our appointment as voluntary administrators, which of course the director was very heavily involved with, and as a consequence, you can only assume that the son-in-law was aware of it as well, had set up a competing company to specialise in this IT division, and in fact had contacted the customers of our company and started getting them to pay the new company for the IT contracts that were on foot. So, of course, we found this out and we marched the director and the son-in-law. We managed to get the director along to this meeting, and the son-in-law and the daughter of the director, and presented this to them. Once we'd done our investigations and established that's exactly what had happened, and that was explaining our decrease in revenue because he was siphoning off the funds to this new entity. So immediately we brought them in, we had a conversation. They denied it to start with and then ultimately did concede that was what had happened. So, of course, we terminated the employment of all three of those immediately. They couldn't be trusted. They were dissipating assets of the company. So we went through that process. And, of course, that left us with a claim against that entity as well for the money that they'd, we would suggest, fraudulently taken. So we had to get lawyers involved in that process as well. And again, another issue that's taking our focus off our main game of just trying to sell this business. And of course, the customer experience through all of this is far from ideal. So you're jeopardizing your value of your customers as well. And just to sort of make things a little more interesting, after going through this process, the son-in-law then made an unfair dismissal claim against us for the basis to which we terminated his employment. Now, this got through to the Fair Work Commission. It got as far as that, and then ultimately it was thrown out. So the matter didn't proceed past that point. But again, we had to get legal advice. We had to get more matters dealt with there, taking our focus off. And another issue that was a little bit unexpected to sort of push things a bit for us was the ATO preference claim. So we identified an ATO preference claim. And we do our investigations and established it was a very clear preference claim. So that's where a creditor gets preferred over the other employees, the other creditors. Sorry. So in that instance, we would say normally what would happen, they're the model litigant. So normally they would if we can demonstrate to them it's a very clear preference claim, they would often enter negotiations with us and do a settlement, usually of a fairly significant sum close to the full payout, sometimes the full amount. That's the normal process because they are the model litigant. And they'll only do that in instances where you can show them, hey, this is a very strong case. But in that situation, even though we felt it was a strong case, they defended the proceedings. So this now required us to take legal proceedings, which required us to incur further costs, getting lawyers involved, all that sort of thing. Ultimately, they did settle for almost the entire entire claim, but that was just, again, another matter that took our focus away from what we were trying to work through here, and another cost. So where this left us, what should have been a fairly straightforward trade-on process, what should have been a situation where we achieved a sale, and we did achieve a sale in the end, but unfortunately, because of all these issues, at a significantly less amount for what was incurred. So as a result of that, we incurred all these extra costs as well, adding to that. So we had a less sale price and increased costs, which of course ultimately lead to much less amount for creditors, and that's not what we were hoping to achieve. And when you recap on it, we had to spend legal costs and time and effort dealing with the dealership matter of that dealership agreement being terminated. That was a valuable asset for us if we could keep that in place. We had the issues with the competitor, trying to steal our customers, trying to steal our employees, and again, devaluing the business through it. We had the issue with the director's son-in-law entity taking customers and making the challenges through that space, and then having to deal with the unfair dismissal claim that fell out of that. The ATO preference claim that I mentioned a moment ago. We had to deal with the redundancy resignations and the Fair Work Act side of things there and getting advice on that side of things. And then the sale of business we did have to do. Now, that one we were happy to incur because that was as a result of us getting a successful sale away. So that legal cost was one we were happy to incur for that very reason. But the others, had they been avoided, we wouldn't have damaged the brand in the way that it got damaged, and we certainly wouldn't have incurred all those extra costs in our time and legal costs. So it left us in, unfortunately, a situation where the return to creditors was far less than had it been. And just an example of how a director, and it's surprising to us why he derailed it like he did, because the best result we can get and pay creditors as much as we can minimises any exposure to him for any personal guarantees that he may have signed or any insolvent trading claims. So if he'd worked with us instead of against us, it would have benefited him particularly. But unfortunately, that's not the way that one played out, which is why we're talking about it today. The next matter that I want to run through is a liquidation scenario. So the first one there was a voluntary administration that did go into liquidation. This one is a liquidation. Now, we've titled it successful liquidation, And the reason being, when it's an insolvent liquidation, and it was to start with, typically the view is, well, creditors don't get paid all their money. And this story doesn't end that way. In fact, it ends in quite a good manner. So some history of this company. This was a company that manufactured clay pavers. It was called Clay Pave, hence its product of clay pavers. A very long-standing, successful business, as you can see on the slide. Started in the 1880s. A very closely held family business, went through 3 generations of families, and throughout that period did extremely well. Then recently it started to struggle. The market changed. Their clay pavers in particular were a little bit less in demand. We were told some of this was due to the decreasing land size for businesses within that area, and they weren't requiring anywhere near the quantity of pavers when they were building new homes. And they struggled a little bit with the change of that market condition, and they didn't adapt. And what I mean by that is they didn't, as sales were dropping off, they were still producing stock at the same level. So they were getting quite a stockpile of stock as they were going through. It was building up. They didn't cut back production. They didn't look at cutting out surplus assets. They didn't look at cutting out over-resourced staff. They still had a lot of staff on. And so they were all things that could have been done to help sort of right-size the business, I suppose. They didn't do any of that. As a result, the profit decreased. And they got to the point where they came to us to look at appointing a voluntary administrator and liquidation process, which is where it went. Now, to just give you a snapshot, of the situation at the time close to our appointment, they had $20,000 cash left. That's all. They'd fully consumed all their cash drawings, and this is a struggle to even pay the wages, let alone any other business expense that they had to deal with. The bank was owed $5.5 million. Now, the reason that debt was there is because they owned the land. So they had the land to which and they had a mining lease on that land. So they would mine their own clay to make these clay pavers and other products. They did do other clay products as well, I should add. They had outstanding superannuation of $150,000. They hadn't paid the staff super for some time. A big issue was the employee entitlement. So they had $1 million in accrued leave entitlements that had to be dealt with. And that's the problem. That's got to be paid, obviously, as you let staff go. So they can't even let staff go and right-size it once they get to this point, because you have to pay the redundancy out and the staff notice out and then their leave out or whatever entitlements they have. You have to pay that as they're finishing up, and they didn't have the money to pay the wages, let alone entitlements. So interestingly, they couldn't afford to fire the staff that were costing them too much money to trade profitably. And then they had unsecured creditors of about $450,000. They were very tax compliant. The tax debt was minimal. They'd done everything right there. Their business practices, other than adapting to the market environment, were all well in play. They'd done everything fairly right until that point. So they did appoint us. Now, prior to appointing us, they did go to the bank. They said to the bank, look, can we secure some additional funding to look at keeping this business going? And the bank said, yes, we'll provide some funding, conditional upon the shareholders putting the same amount of funding into the business. And the shareholders didn't want to do that. So ultimately, as a result, they didn't have any cash to go, and they had no choice but other than to close the doors, and I'll talk about that scenario shortly. They had no choice but to look at some kind of external administration appointment, and that's what they did. And in doing that, what it gave is this, it did compartmentalise this pre-appointment debt, just put it off to the side and gave some breathing space. We came in with certainly our expertise on talking what strategy could work for them and what it might look like going forward. So we worked closely with them without the urgency of this debt. We managed to just put it to the side for a moment to give that breathing space to work through what the strategy may well be. So the strategy that we took on with them was as follows. So the first thing we did, we could quite clearly see what needed to be done in terms of right-sizing and downsizing the business operation. It was overstaffed. That was one of the first issues. The production needed to slow down, the costs associated with that, because they've got a big kiln, a big oven to make all these products, and the utility cost in keeping that going was huge. So scaling that back and just getting, and because you had this enormous stockpile of stock that they weren't selling. So certainly a strategy was to get that out, but it was right sizing the business, bringing it back to a more sensible level, but doing that carefully over time. It's not, we didn't just come in on day one and implement this. We worked out the strategy, and then we slowly worked through the strategy over time. And in doing that, we got to work with the employees. That was a critical factor. because of course they're nervous about their jobs, and ultimately the strategy was to close the business down, but to do it in a very, very strategic and careful way. And part of that, we had to let some of the staff go. They just weren't needed, especially when we're cutting back on production. So, but we gave them time. We worked with them. We allowed them to start looking for other jobs whilst they were still with us. And by them working to a point where they had another job, we didn't have to pay in lieu of notice. They certainly had to get their leave entitlements, as they're entitled to, but allowed them to do that in a very careful way and didn't leave them without a job. So that it kept staff morale happy. And what that did also is it meant the staff were happy to work with us. We had them on board. So that was a very important thing. So we proceeded on this downsizing the business. We cut back, as I said, all this production of pavers. It was just producing pavers that couldn't be sold. And then we got into a very extensive sale process of the pavers we had. Some of it was obsolete, old stuff that had been sitting there for so long, so we discounted that just to get it sold. And of course, selling the existing stock that had been there at full retail price. So we're getting good value for this with no cost, less cost of production. And as we'd scale back the production, there became surplus assets around the business premises that we could start to offload. So we did a careful sale process to the point where production stopped entirely. We sold everything on the property. And then once we had that, we could then look at the next step, which was the land. Now, the land was a challenge. And the reason it was a challenge is because it had a mining lease on it. There are environmental remediation requirements of any lease, as many of you probably be aware. So, and there can be significant costs to that. So it was a real challenge for us to sort of get out of this land without being lumped with the remediation costs of the mining lease. So we went to market, but the idea was we wanted to sell it all as one package. Whoever bought the property, we wanted them to take the mining lease as well. That was a really important factor for us to minimise the exposure. And to give you an example, some of the offers we received on the land was $1 on the basis they would take over the mining lease. So that was certainly very lowball offers, but that was some of the offers we received. So we worked through that process, and we did manage to sell the property with the mining lease attached, and we ultimately sold it for $7 million. And through the entire process, and that included them taking on the mining lease, and we got to walk away. And as I mentioned earlier, there was $5.5 million owing to the bank secured over that property. So of course that paid them out straight away with a little bit of change left over. Then on top of that, through the whole process, we'd sold stock for about $7 million. So in total, we'd recovered $14 million back over this period of time. And this wasn't overnight. This was over a considerable period of time. But in doing that, we'd maximise the return on the sale of the assets, the sale of the stock, and the sale of the land, as well as looking after the employees and minimising any employee costs. So what that meant for us, everyone got paid. We had enough to pay the employee entitlements in full, critically. We had enough to pay all the creditors in full. And in fact, with the creditors, it did take time. So they were without their money for a period of time. That's unfortunate. But there is a section in the Corporations Act that provides they get interest on their debt when we pay everybody in full. So they got approximately 8% interest on their debt as well. So they actually received more than just what they were owed as a principal debt. And it also, by getting this scenario, it also enabled the directors to have some comfort that there was going to be no actions taken by the liquidator against them. So it ensured, for example, we look at things like insolvent trading, other voidable transactions. Because the company wasn't insolvent in the end, everyone got paid in full, then that wasn't a factor. So for them, they had comfort that they weren't going to get pursued by a liquidator for any such claims. So the key takeaways from this, I suppose, and these are the learnings that we love to share, is if we go back in time to when the appointment occurred, they had a number of alternatives available to them. They were at that fork in the road where they had $20,000 left in the bank and this debt that we spoke about. They could have continued to try and trade the business, but of course they didn't have the funds to do it. So the only way they were going to be able to do that was to put the additional funding in. And from what we know, that would have been through bank financing and the shareholders having at the same time to throw their money into it. Now, it's one thing to throw the money in, but if they don't make any fundamental change to the business, it's nothing more than a Band-Aid solution. They're going to be in the same position in 6 months, 12 months, whatever time period it took for that money to run out is when they were going to be in exactly the same scenario that they were now, unless they made that fundamental shift in the business. Those decisions that we made unless they got some assistance to make those decisions, they were going to be in exactly the same position. In fact, worse, because the shareholders are going to be out of pocket and the bank's going to be owed a lot more. And that may have changed the way things played out in the end. And this is a conversation we have with many businesses all the time. It's about don't just go get funding to fix it. Sometimes they'll go to family and things like that. And to be honest, it's the worst thing they can do, because all they do is lose that money if they haven't changed the underlying issue. They just think money's going to make the problem go away. And this is a perfect example of how that's all that would have happened. The other option to them, of course, was just to close up. Just go, well, we've got no more money left, nothing else we can do. We're just going to close up shop now. Now, if they did that, they would have been left with all this stock. How are they going to realise the stock? Is it something they would have had to go to competitors to see if they would buy the stock, or were they going to auction it? What were they going to do then? Because they also had a very big bill that would have crystallised immediately. If they'd shut up shop, they would have had $1 million of employee entitlements crystallise straight away that they would have had to pay. Now, clearly they weren't in a position to do that. So I expect it would have been likely a straight up liquidation without the ongoing trading. So there would have been that challenge. They didn't have the funds to do that either. And then they would have presented another challenge with what were they going to do with the remediation work and things like that in terms of the sale of the property. So those sort of the two options really was go get some more fun, other than the one that they picked, go get some funding, just shut it down. Or the third option was to do a strategic rundown, which is what obviously they chose, and gave a significantly better result than the first two could have possibly achieved. So they did the right thing there, which was fantastic to see. It also meant, as the slide says, no more cash injection was required. And the directors had comfort that hopefully if all went well, they weren't going to be personally exposed either. So that worked out well. So that's where the advantage of acting early can be. If they'd left this from much later or just tried to trundle along for a bit, the position would have been significantly worse. So the key takeaways from this is the company doesn't have to be hopelessly insolvent to benefit from the regime. In this case, they were clearly insolvent, but with the value of the asset and the stock, they end up having enough to pay all creditors in full. The big process here, the voluntary administration regime gives that breathing space. In both the first case and the second case gave an option for a strategy of a sale of a business in that first case, or in this instance, a controlled close down and sale of key elements of the business. And just sort of put that old legacy debt aside for a moment to give that breathing room. And that's where it's a very, very useful process. In this instance, no stress for the director. They got to hand it over to us. We took it, we dealt with it, we put the strategy in place, and we got the result in the end, and they didn't have to be concerned. And hopefully they were looking at, we didn't know how much we were going to get at the start, of course, but the hope was certainly to get a significant sum, in this instance, enough for them not to be concerned about voidable transactions either. And despite perhaps what people might think sometimes, there can be circumstances where everyone gets paid in a liquidation scenario that starts off as an insolvent one. So yeah, that was certainly some good results there. Now, the next matter we want to talk about is one of a synthetic cannabis dealing bikie. So I mentioned before at the start, there were two types of appointments that we can start off. The one is where we're voluntarily appointed, which is what the first two cases were. And then one where we just get nothing more than a court order. And that's the scenario that we had here. We had a gentleman that was made bankrupt by the ATO. The debt owing to the ATO is $16 million. Now, if you think back, how much synthetic cannabis do you need to sell to raise a $16 million tax debt? One would guess a fairly large amount. Now, some of that's interest and penalties, of course, but that sort of got our attention pretty straight up, pretty quickly. It was legal. It was absolutely legal. There was one thing that was interesting on the file. I've been doing this for 24 years and never seen this. And there was a note on the file that if trustees were appointed, to contact the police immediately. So straight away we thought, well, we're in for a bit of a ride on this one. So what turned out, it was a former motorcycle gang member. He had left the gang, and unfortunately, as a result of that, had suffered some pretty serious physical attacks, and assets had been stolen and things like that. Just a sort of usual story you hear about. So we got in. He was very cooperative with us. He gave us a statement of affairs, but gave us no records. He had nothing, and that's probably not surprising. A lot of cash transactions, as you can imagine. So we got underway and started doing our investigations and started ticking away with what we could find. So one of the first things we looked into was motor vehicles. We found 15 registrations. So immediately sort of our ears prick up and go, oh, where are these vehicles? What's going on with them? We've got a duty to collect them, to sell them, that sort of thing. We worked out pretty quickly with the help of the bankrupt that most of those related to personalised plates, which had long since gone. There were a couple that were some that was sold or stolen before our appointment. Some of the sales were to people with the names of Big Charlie and Snakebite. Now, that's dead set the truth. We didn't have much luck in finding Big Charlie or Snakebite to see and get the evidence about the sale of the vehicles. But anyway, that's where we ended up with some of those motor vehicles. So unfortunately, no real recoveries from that avenue. They were all long gone. We did identify some properties owned or partly owned by the bankrupt. There were 4 properties that he had a half interest in. Now, there were some non-consorting laws in place that he actually wasn't able to contact or be involved with at any point the parties that were joint owners. So straight away, we're thinking, well, this is going to be a little interesting. So we started down that road and we had no records, of course. So we're trying to work out what the position is. One of the first things we do in any bankruptcy scenario with property is we look at the equity position. So to do that, we get a value of the properties, and then we look at what the debt attributed to any mortgages or securities held by banks over the property. And if there's equity where the value exceeds the debt, then of course we look at how we realise that. In this instance, perhaps a blessing, I'm not sure, because I don't know how we would have gone securing and selling the property when we're only a part owner of it with the kind of colleagues that we'd be dealing with. There was no equity. The debt exceeded the value of the properties. There was nothing there. So it was a matter where I didn't have to take that any further. There was one property, however, that wasn't registered in the bankrupt's name, but we found out he had purchased it, sort of. So there was a former clubhouse of the bikie gang. The bankrupt had told us that there was $368,000 paid for this property, and he paid cash. But just to make things a little more interesting, records were hard to come by, and eventually we did get some records, and I'll explain that process shortly. We found that the property wasn't sold to him. It was sold to an associated trust where the corporate trustee had been deregistered. So we have a trust that was the purchaser of a property. Corporate trustee had been deregistered. The directors of that corporate trustee were the bankrupt and his wife, who was also bankrupt. So they were disqualified from acting in any case. But to make things a little more interesting, the property never transferred from the vendor. The seller never transferred it to the new trust. So we had a situation where the seller was still on title as the owner of the property, although he was very happy to get it out of his name if he could, because he was still getting the late rates notices, land tax notices, things like that. So he was very happy to get out of his name if it could be done. But bankrupt had told us he'd pay $368,000 cash for it, and yet the contract refers to it being held by a trust that doesn't arguably exist or can be dealt with because the trustee entity is deregistered from the ASIC. So, of course, we've got to start to piece all this together, work out, well, what's happened, what's going on, where's the evidence? So with we needed to determine who evidence that he paid it. Now, you would think getting bank statements would help us out with that. The money came through from the sale of some tattoo parlors somewhere, so we sort of had to try and trace that through. We couldn't get our hands on records very easily. The police held some records and were refusing to release that information to us, and again, I'll talk about that shortly. So that was making it even more difficult for us. We did get some information for us to start to trace through. The lawyer who was acting in the sale, we couldn't. They stopped practicing, and we couldn't find them to get information out of them. And there were other lawyers that didn't have information either. So it was proving to be a very challenging situation for us, because we weren't even technically the purchaser. The bankrupt wasn't technically the purchaser, and we're just trying to work out what interest he has, because his interest, of course, vests in the trustees in bankruptcy. So we started having to look down the road of avoidable transaction on the basis that he'd paid for a property that was by way of contract purchased by another entity. So whether or not that's a scenario that we could be looking at attacking that transaction like that. And then we had to look at the trust law position, the beneficiaries of the trust, and we didn't have the trust deed. We didn't have this information. So that made all of this very difficult for us. So once we worked through for some period of time in getting the records, we managed to piece together enough to take the following action. So what we could do, we lodged caveats over the property pretty quickly, just so that we could secure the property, make sure it doesn't disappear. We then had enough evidence to go to court. We made an application to court for directions for avoidable transactions. So we went to the court saying, we've got enough here to show we feel that $368,000 was paid by the bankrupt, and the property should not have gone to the trust, because they didn't pay for it, it should be transferred back to the bankrupt. But of course, the trustees and technically the entity that controls the property, because they're technically the entity that should purchase it once they get on title from the vendor. So the court made ultimate directions that we be appointed trustee of the trust and that we be able to sell that property, and that all proceeds from the sale of that property would go back to the bankrupt estate. So we did get the result in the end. It was a lot of paperwork and whatnot to get to that point, but we managed to do that. What is a little ironic, I suppose, at the outcome of this is we went to market, put the market properly on the property on the market as we normally would do, went through an entire sale campaign, and the vendor was ultimately the purchaser of the property. So it was a scenario where he did get the property back. He held other properties within that precinct, so he was quite happy he felt there was going to be a commercial gain for him in getting it back. So he did end up purchasing it in the end. So other issues we had to deal with, he had a number of directorships of companies and a partnership. Again, books and records were very thin and hard to come by. So we had to establish, was there any interest that the bankrupt held in these businesses? And they had businesses like that on the screen. We had tattoo clinics all over the country. We had a trustee company that I've already spoken about that was deregistered. But we couldn't locate any records to determine what was the financial position of each of these businesses. Did he have a stake in each of these businesses? And at the end, we were unable to prove anything. He didn't have any shareholding in the companies anyway, so there was no direct vesting in that share scenario. He was just a director of those entities. And of course, because he's bankrupt, he's disqualified from acting as a director. So at the end, those investigations went nowhere in the end because we couldn't prove a direct link. The books and records, this was absolutely a challenge for us. We had a scenario where we couldn't get our hands on the books and records at all, as I explained earlier. The police were holding them. They refused to give them to us originally. We issued what are known as Section 77C notices on the police, which is a requirement for them to release the records. They still refused. Normally, there's penalties imposed for refusal to comply with such a notice. So we went round and round on that a fair bit. Ultimately, we did get the release of some records, enough specifically to the property to allow us to make that court application that I spoke of. So we did get there in the end, but it was certainly a challenge. There's no doubt about that. And the next element we had to deal with was his employment. So many of you may be aware of the income contribution regime. So this is where someone who is bankrupt, if they earn over the threshold amount, they pay a certain amount to their trustee in bankruptcy. So in this instance, we determined the bankrupt could earn a salary of between 170 and 200,000 if he went and worked in Papua New Guinea, PNG. And that would provide income contributions of approximately $30,000 to the estate each year of bankruptcy. So over 3 years, approximately $90,000. But to do that, he had to travel to Papua New Guinea. And the ATO prior to our appointment, had a non-departure order on him to make sure he couldn't skip the country. And they refused to release it. So we were going back and forth with them explaining, well, look, if you release it, we can bring another $90,000 into the estate. I know it's only a drip in the ocean to the 16 million you're owed, but it's still going to get you something back, combined with obviously the sale proceeds of the property. They wouldn't do it. They wouldn't do it. We talked to them at length. We outlined to them we felt there was an inability for them to enforce anyway because of the provisions of the Bankruptcy Act, and creditors can't take action once the bankruptcy occurs. So ultimately, after a lot of toing and froing, they did concede and allowed the bankrupt to travel. Unfortunately, they didn't really complete their paperwork, and he went to, he was in Cairns to fly out to PNG and got stopped at the airport there on the basis that the non-departure order was still in place, even though the ATO had confirmed they had removed it. So there was a bit of a stuff around there as well. But ultimately, he did get to go and earn the income that we needed him to earn to provide a return to the estate. There were also, on a side note, there were some money laundering charges against him that the police were taking further. Ultimately, he defended those, and ultimately those charges were dropped. So it just sort of shows you the scenario we found ourselves in with this sort of person. So the last one I want to talk about is that of the tale of two angry brothers, two cats, and some fish. So in this scenario, again, it's one of those creditor-style appointments where we have a court order confirming where to be appointed, and that's all we know. So in this case, to give you a bit of context, a bit of background, we've got Tom and Jerry. We've named them, obviously not their real names. Tom and Jerry owned a residential property together. Tom lived at that residential property. He was and had been for some time. There was a breakdown in the relationship. They didn't get on anymore. And Jerry went to Tom and said, look, you need to buy me out or we're going to have to sell the property. I want my share and I want to move on with my life. They couldn't reach an agreement, and this went on for a number of years. And then ultimately, Jerry had had enough because Tom refused to do either of those options. Jerry had enough, and he made an application to court to have the appointment of a statutory trustee, which is where we came in. So we got appointed statutory trustee. Our job was fairly straightforward: sell the property and pay the money out to each of the estate. That was each of the owners after costs. It's a fairly straightforward process for us. We do this day in, day out. So once we got appointed, we then need to contact, we don't know anything. We've got a court order saying we're appointed. We know the property address, but that's about it. So first step we always take is to contact the owners to get their story. So in this instance, we contacted Tom first because he made the application. So we spoke to him and got a bit of a lay of the land. So the lay of the land was, it was a residential property worth, call it at that point, he thought 700,000, mortgage of about 445,000, equity of about 255,000. So in doing that, clearly there was some equity there. So there was no issues with proceeding to sell a property and paying the bank out in the first instance, because of course they have to get paid pursuant to their mortgage. The costs scenario, any costs incurred in selling it, being all costs of sale plus our trustees' costs, were to be taken out of the share of Tom first, and then in the balance will get split first, any costs against Tom, and then they both get their share of the property afterwards. There's a fair bit there, equity of 255,000. So at this point, we're thinking this is pretty straightforward. Sometimes it can be a challenge for us to get someone who's living in a property out of the property. In this instance, the court order for our appointment gave a requirement for the property to be vacated within 14 days of our appointment. So when we saw that, we thought, okay, we're pretty good. This should be fairly straightforward, fairly vanilla for us. No, that's not what happened. We then got in contact with Tom on the property. Sorry, my lights just got one of those energy efficient lights and it keeps cutting out. We then got in touch with Tom and said, look, this is the situation. We got his side of things. He didn't want to deal with us in person. Had to be via email, refused to answer the door or anything of that nature. Everything had to be by email. So we did that. And then once we've done that, he said to us he's not moving out. And we said, well, there's a court order saying you've got to get out. And he said, no, I'm not doing it. And then ultimately said, oh, well, look, I can't do it in those 14 days. Can I have longer? We said, well, we don't have discretion. There's a court order saying you've got to be out by this day. But look, if you're going to be out within a week of that, look, we won't take any further steps on it if you can get out. Then that date kept getting pushed out by Tom, and it became pretty clear and pretty quickly clear to us that he was not moving out easily. So that put us in a predicament straight up that we're going to have to deal with trying to get Tom out. We worked around as best we could on that. Jerry at the same time was getting a little unhappy. Jerry said, look, he's got to be out. The court order says he's got to be out. Why isn't he out? We want this property sold. We've got money we need to pay back to the mortgagee. The longer they're in there, the more interest we're paying, the less I get. And that was a fair request from him. So we had these two competing interests that we had to deal with. We then, unfortunately, had no choice but to then make an application for an enforcement warrant to get Tom out. So we started that process because Tom was just being very, very difficult throughout the whole side of things, threatening to go to the media, going to be thrown on the streets, all that sort of stuff. Then we had something very peculiar happen. Tom and his partner, who was living at the property with him, were both arrested on domestic violence charges. So they disappeared. We found this out through family of Tom and Jerry. That's when we became aware of it. Fortunately for us, the next day was when our enforcement warrant hearing was. So we thought, all right, we'll wait for our enforcement warrant hearing. That happened the following day, which then gave us access to move in on the property. We knew he wasn't going to be there, so there was going to be no confrontation, which took out a big problem because he wasn't going to come out of the property quietly, that's for sure. So we managed to get in and get access to the property. So, okay, great, we've got access to the property. Now we can do what we need to do. That's when we realised how interesting things were going to start to be. So firstly, the property was in complete state of disrepair. It was a disgusting mess. The place stunk like nothing else. There were holes in walls, all this sort of damage, the usual things, plus just his belongings everywhere. and we've got to deal with all this. Our ultimate goal is simple. We need to sell the property, but we've got all this happening. And then what became very quickly apparent to us is there are some pets within the house that had just been left there because, of course, they'd been taken away by the police. We had 2 cats and some fish. So the 2 cats became quite an issue for us. So we weren't prepared for that when we first showed up at the property. So we were only securing it, changing locks, all that sort of stuff, and have a look around. That was our first idea of what we're dealing with. So we had to leave the property at that point with the cats there. So we turned the air conditioning on, we made sure there was food and water and all that sort of stuff, and then walked away going, well, how are we going to deal with these cats? We fed the fish too. The cats became a real issue. We contacted RSPCA and Animal Welfare and things like that, and they refused to take it on the basis they needed the owner's consent. They wouldn't deal with the cats without the owner's consent. So we started thinking, all right, well, what else can we do? So we started talking to boarding kennels and catteries and things of that nature. But of course, they ask the usual questions they ask. Have they been vaccinated? How long are they going to be here? And we're thinking, how's this all going to be paid for? So this was quite the dilemma for us because we couldn't answer those questions. So fortunately for us, the next day, it was a Friday night, we got a call from Tom's partner. She'd been released from the watch house. And they were her cats, and she made some pretty serious threats to us about getting access to cats, and if we don't give them to them, what would happen to us. So this was going to solve our problem. If she could take the cats, then at least that's that problem out of the way. So we then attended the property the next day with the police. Showed up on site because of the threats and the nature of those threats. We weren't going to go out there unaccompanied, and she was well known to the police. We found out when we got there, and we'd spoken to the police. So we showed up at the property with the police. She'd actually slept in the backyard that night. So we showed up, and she sticks her head up over the fence and says, "Oh yeah, I'm here." So we let her in. We're standing there at one stage. I was on site myself. This is a Saturday morning. The police officer and I are standing there just looking at each other in a hallway. And these cats are running up and down the hallway, and she's running up and down the hallway with them, trying to catch the cats to get them out of the house. So that was an interesting experience. And long story short, we got her out with her personal belongings, enough that she needed, things of that nature. We fed the fish because she wouldn't take the fish. The fish was still there. So we then had her out. So we were then faced with the scenario. Thankfully, we've got rid of the cats, so now we can proceed, but we needed to get Tom's belongings out. So to get Tom's belongings out, we had to get removalists in, and that came at a considerable cost given the disgusting state to which they were in. So we got the removalists in to get his belongings out. The fish throughout this whole process is still getting fed and looked after at this point. And finally, once his gear's out, we have a vacant house that we can look to sell. But at this point, once the furniture was removed, the state of disrepair became very, very clear. There were holes in walls. There were the place that the carpet just was, the stench was unbelievable, to the point where the only option for the carpet, the real estate agent said to us, it's impossible to sell this property. Even if you did, there's no way you would get enough in its current condition to pass the mortgage debt. There'd be nothing left over. So we were in this predicament of what do we do with the property? It's in no state for sale. We've just been appointed by the court. We've got no money at this point. We've already incurred significant costs. So who's going to pay for the cost of the repairs? So we got quotes done. We had people come out, quotes for replacing the carpet. We were concerned that the smell was going to seep through the concrete, but we had replaced for the carpet, fix the walls, paint the interior, all this sort of stuff. We went back to both parties. By this stage, Tom had been moved to a facility that we could email with him at that point. So we emailed both of them. They didn't want to pay for the costs, of course. So we had the decision, were we going to pay for the costs, which is what we did. So the work was finally done some 6 months later after our appointment. That's how long it took to get him out, then get the works done, and then actually get it ready for sale. We then went to sale. We got it on the market. We received numerous offers. We had one contract that was on that ultimately fell over, and then we got another contract on, and we managed to settle the property in July 2023. This here is, I apologise if it's a bit hard to see, but these are the numbers of what we got out of it. So the column on the left there called actual, we sold the property for $740,000, paid out the usual costs. So there was rates that had been incurred of $26,000, mortgage of $472,000, agents' commissions, leaving net sale proceeds of $224,000. At that point, we're required under the order to split the money and take out the costs of Tom's share, and Jerry picks up the. What it should have looked like was the right-hand column. Sorry, we're just getting comments that the stream has cut out. I'm not sure if anyone's still online. I'll proceed on the basis we are. I'm not sure if anyone's still here, but we'll proceed on the basis we are. So what should have been the outcome was the column on the right-hand side. What should it be? So we shouldn't have had to incur the extra cost. So what should have been incurred there was simply the less the trustees' cost. Instead of being 104,000, but it was in fact should have been 25,000. And then the trustees' fees should have been 25,000. So the total cost should have been significantly less, leaving available funds of 174,000. And in doing that, Jerry should have received 112,000 and Tom should have received 62,000. So in hindsight, had Tom been cooperative and not being as difficult as he would have been, he should have received $62,000. On the other side, Jerry would have received an additional $74,000 over and above what he received. So that's the outcome. By Tom being as difficult he is, which achieved nothing other than him losing any chance of any money, that's where the position ended. So how does the story end? Well, firstly, Tom, he got released from jail sometime just before the settlement of the property, and he ultimately collected his belongings from our agents. Jerry got his money, not as much as he was hoping to get, but certainly got some money. But he had closure that the matter was finished with. And of course, the fish, what happened to them? Well, one of the tradies took the fish. He'd been feeding them the whole time. And ultimately, we agreed for him to take the fish back to his family. So that was a great outcome. So look, that's the end of the presentation. So what I do want to talk about is our Worrells community. We've got a Worrells community of different people we deal with. We deal with a lot of people over the places in these spaces, business brokers, finance brokers, R&D experts, all the like that it's been up on the screen. So if you've ever got anyone that you're not sure in your own network, you go, oh, well, I've got a client that wants to sell a business and I just don't know any business brokers, please reach out, because we only pass on referrals that we can vouch for, that we know do the right job, and we're happy to share those with our community. So just a reminder that that's what option is there. We'd also like to take this opportunity to talk about an upcoming series we have next year, particularly aimed at the accountants. We've got a CPD tax series coming up. There's going to be 11 monthly presentations starting in February, 15th of February, as that's up on the screen, where we're going to do an hour each month on tax. We've partnered up with Webb Martin to do it. It's not insolvency related at all. This is definitely one for the tax people out there. Just to give some additional hours of CPD. So 11 hours over the year for this at no cost. To get onto that, all you need to do is jump on our website and register through our website. All the information is there. You've got a bit of time, got 2 months before the first one. So please take the opportunity to jump on and have a look. And that's what we've got. So that's pretty much what we have for now.
Thanks, Chris. Thanks for such an engaging and informative presentation. I do believe we have lost the live stream, but we are recording, so we will proceed to ask the questions so that the recording can be forwarded to the participants afterwards. We only have one question, and that's from Joe Quinn. And he was just querying as to why the fair entitlement guarantee doesn't apply when there's less than 15 employees. I'm assuming that's in relation only to redundancy because it's a small business employer, but did you want to just speak to that a bit further, Chris?
Yeah, so under 15 employees, you don't get redundancy. It's not paid. I believe there is actually talk at a government level to try and change that, which would be a wonderful thing. But putting that aside, that is the law for now. To qualify, it's people resigning for insolvency purposes. So I imagine it's probably a question is from 16 to 15. And that's what we were perplexed about. We're of the view, if they start at 16, then you're entitled to redundancy. And if people get resigned during the period due to the insolvency of the company, but FEG took a different view to that. And that's where the legal advice came in and whatnot through that side of things. I wasn't involved specifically on that legal advice, so I can't give the legal answer onto that. But at the end of the day, it was a situation where FEG were not going to pay for the redundancy and we didn't have sufficient funds to pay it ourselves, as I understand. So that's sort of where that one ended up, unfortunately.
Yeah, it'll be good if they change that law.
Mm.
So we don't have any other questions at the moment, but so we'll thank everybody for tuning in, and again apologise for losing the live stream. As Chris spoke to before, we're looking forward to having a big 2024. We've got looking at holding enough CPD events to provide about 20 plus hours of free CPD to everyone during the course of the year. So thanks again, and on behalf of everyone at Worrells, we want to wish you a safe and happy holidays, and we look forward to seeing you again in the new year. Thanks, Chris.
Thanks, Kristen.